Hi everyone, good afternoon. Thanks for joining us for the webinar today. Sorry we're a few minutes behind schedule. We had the not just the proverbial but the literal technical difficulty. So thanks for hanging in there for a few minutes. But we're ready to get started now on the webinar Request for Equitable Adjustment and Claims. My name is John Williams. I'm one of the partners here with PilieroMazza, and I'm joined today by my partner, Cy Alba. We're both in the government contracts group with PilieroMazza. And like I said before, we're happy for you to be with us today. This is the first part of a two-part webinar series that we're doing on contract claims. And the next one will be coming up in a few weeks, and we hope you'll join us for that as well. For those that aren't familiar with our firm, PilieroMazza is a law firm in Washington, D.C. We're most well known for our government contracts practice, but we also have robust practice groups in the areas of labor and employment, corporate and mergers and acquisitions, and litigation. And I really encourage everybody to sign up for our newsletters and other information we put out, and check out our blog to see everything that our attorneys are up to. So where are we going today in this webinar, Request for Equitable Adjustment and Claims? We're going to start with an overview of what is an REA and a claim, and sort of describe the differences and give you a basic understanding of those tools. And then we're going to build on that by giving you considerations and tips for REAs and claims that we've picked up from representing a number of clients in these matters. We're also going to spend a little bit of time focusing on subcontractor claims, because those are handled differently than a claim by a prime contractor. And then we'll end with an overview of the claims appeal process. After a claim has been denied, where do you go from there? And in the time that we have left, for those that are willing to hang on, since we got a late start, I'm sure we'll be after 3 o'clock at that point. Cy and I are willing to hang out and answer questions and go long for those of you that are willing to stay. So please feel free to type in your questions at any point. We'll answer them in real time as we can, and we'll save some time at the end to answer more. And then afterwards, any questions that we couldn't get to today, we will email you directly. So feel free, don't be shy about submitting questions as we move along. And everybody will get a copy of the slides. That's a common question. We will be sending out the slides to everyone that participated today. You'll get an email either later today or maybe tomorrow morning with the slides, and then we'll also be posting the slides as well as the audio on our YouTube channel within the next day or so. So one way or another, you'll be able to get to the slides and refer back to this, or feel free to forward it on to colleagues, etc. And then a final note here, like I mentioned earlier, that part 2 is coming up on August 19th. That's going to address claims related to contract terminations. So we're not going to really touch on contract terminations today, but we encourage you to join us for that webinar in a couple weeks. And now I'm going to turn it over to Cy, who's going to talk about REAs and claims.
Afternoon, everyone. So REAs versus claims is a common question that we get from a lot of clients. And a pretty basic way to look at it is REAs are negotiated resolutions that are non-contentious or as amicable as possible, and they occur during performance of the contract before contract closeout, while claims are more contentious issues, actual disputes between the parties, and they're more formal filing. In particular, when you're dealing with a claim, it has to be put together in a specific way, meaning you have to state a sum certain, you have to be seeking some sort of adjustment or change in the interpretation of the contract, or some other actual relief that's directly related to the contract, whereas an REA, or request for equitable adjustment, it can actually be a request for some relief based in equity, which is sort of fairness. Even if it's not directly connected to the contract, you could still request some relief be granted. Now, of course, if an REA is denied, the only option is to file a claim, in which case certain things that are based purely in equity would go out the window. But just remember that the main difference is REAs come during and claims come after, and claims are much more contentious. And in addition, I just want to note that with regard to claims, you can also challenge CPAR, poor CPAR ratings and things like that. That's another common question that comes up. So challenging a CPAR rating is something that would fall under claims. So just keep that in mind. When you're looking at REA basics, REAs generally have to be submitted at any time during contract performance or during the closeout period, but they cannot be submitted after closeout. So if the contract has already been completely closed out, at that point, you're generally foreclosed from submitting an REA or filing an REA. You can still file claims, however. You normally have to assert your rights to an REA within 30 days of some change giving rise to increased costs or something like that. So whether the government explicitly asks you to do something new on the contract, or there's some sort of constructive change to the contract where you've encountered something which has increased your cost or something that was not anticipated, that would be a potential ground for an REA as well. Now, failure to give 30 days notice doesn't automatically bar you. The government still has to be prejudiced by your failure to act within the 30 days, and that's something where it's a little bit of a wishy-washy standard, but the courts have not been so eager to foreclose people's claims or REAs, challenges to REAs, just because you are outside that 30-day window, unless the government can actually show they would have done something different to save money, to reduce the amount of your REA and or claim. There's no particular format, and an important difference between REAs and claims is that legal fees, accounting fees, the time that you as a contractor spend trying to put the REA together, if you're tracking that, which you should be under a separate category, labor category or something to that effect in your accounting system, all of those costs are something that's recoverable in the REA, and you can make it a line item of the REA.
And I just want to add on that point regarding legal fees, and we're going to get to this in a later slide, but I think it's important to point it out here that you want to be careful about how you're couching these preparatory fees, because from a key difference, as I mentioned, between an REA and a claim is that a claim signals a formal dispute, whereas an REA is more part of a negotiation or trying to iron out something during the performance of the contract. So particularly for counsel, if you're describing the time that you spent advising your client in terms that signal a dispute, like, talked with Mr. Smith regarding his dispute with the USDA, it may be difficult to recover those fees later if they were assistance in an REA, because the word dispute sends a signal that really you were gearing up for a claim even at the time you were working on an REA. So, and we did get a comment that the audio cut out for a few seconds, so if anyone else is having similar issues, please let us know. Maybe it was just that one person's computer, but if more people are experiencing that, just shoot us a little note. Thanks.
All right, and with regard to claims, some of the basic issues with claims, there's a 6-year statute of limitations from when the time the claim accrues. So that generally, the time it accrues is important, because just because something happened and 6 years goes by, it doesn't necessarily foreclose you if your claim didn't completely accrue by that time. So if you were attempting to negotiate certain issues, working through a potential question and the government was assuring you that there would be payment forthcoming or something to that effect, and then you were told later that they were not going to pay it at all, then that's sort of whenever your claim would necessarily accrue. So this, just remember, generally speaking, there's a 6-year statute of limitations. So to be safe, whenever you start to incur costs, I would think about it from that date, but it's not always the case. When you're talking about stop work orders, claims should be filed within 30 days after the cancellation of the stop work order. So if work goes back on track and you've incurred certain costs within 30 days of getting back into the contract, you should file your claim or notice of your claim. That too, though, like with REAs, if you are outside that period, the question then becomes, was the government actually prejudiced by your late notice? So if you give notice, 40 days, 60 days after some sort of incident occurred where you've increased cost, the court, if they ever review it, would look at whether or not the government actually could have taken action during that additional 30 days to reduce or otherwise avoid the claim amounts. So unfortunately, whether or not the government's prejudice is a question that's reviewed after the fact. So hindsight is 20/20. So it's always good practice to stick within these guidelines that are in the FAR with regard to the 30-day notice period. No particular format is required with a claim. It's just normally in letter format. And the more detail you have in an REA or in a claim, in fact, we normally say if you're going to do an REA, write it up just as you were doing a claim or a full-on appeal of a claim, so that you have as much detail and facts in front of the government as possible, because that will help you later. If you want to convert it to a claim, it's just a simple process. And certifications might be required for REAs, and they are required for claims. So with an REA, generally, you don't have to provide any pure certification. However, if it's a DoD contract and DFARs apply, there is a certification requirement if the REA amount that you're requesting exceeds the simplified acquisition threshold, which as of right now is $150,000. So if your REA is over $150,000 in claimed amounts, you have to submit a certification that it says that the REA is being made in good faith and that all the supporting data and statements that are made in the REA are true or accurate to the best of your knowledge. Any REA that's exceeding $100,000, which is less than the simplified acquisition threshold, so that's not a typo, anything that exceeds $100,000 can then be converted into a claim, but you have to put in the full claim certification, which, as the slide's popping up, is that the request is made in good faith, all the supporting data is accurate, so that's the same as the DoD REA, but you also have to certify that the amount requested accurately reflects the contract adjustment that you believe the government's liable, and that you're authorized to submit this and make these representations on behalf of the company, whoever's signing the certification. And this certification, whether or not you have an attorney or a consultant or anyone else help put the claim together, the certification has to be signed by someone within the company who is authorized to do so. Usually the president or some sort of vice president. If it's a larger company, it could be a vice president or someone who has actual authority to bind the contractor. We're going to now move into some tips. This is sort of the meat of the presentation about when you're filing REAs, claims, and certain specifics on what claims can be brought and how that works. So with regard to when you're filing an REA or claim, we recommend filing going the REA route instead of jumping just to a claim if you have a good working relationship with the government and you think that there's some possibility that you can get to a negotiated resolution. So things haven't devolved to the point where people are yelling at each other or something to that effect. And believe me, that happens a lot. So if you've gotten to the point where there's either some sort of amicable dispute, or not dispute, amicable discussion, I should say, or the government has said specifically, hey, we'll pay you, but you got to file something formal with us, then you might want to go the REA route. Whereas the time you might want to skip an REA is if you think it's just a complete waste of time. The parties are already at each other's throats, or the government has already said, we are not paying for that. At that point, you might as well just file the claim and start the clock running on the government so that you can continue to move the process forward. So whether or not you're filing a claim or an REA, these are just some examples of items that you can include and might want to include in your REAs or claims, and we'll go through these in more detail. And generally speaking, a contractor is entitled to your actual costs for any sort of additional time or materials that you've incurred because of some government action or inaction, and you can generally recover profit, overhead, G&A, and any sort of bond costs that you've incurred. That's more for construction projects due to some sort of government action. And just to talk about, we're going to go through most of these, but we don't have another slide on variation estimated quantity. So just so everyone knows, that claim is, or REAs, can only be brought if the variation in quantity that you expected for a supply procurement, you're providing a certain number of goods. If that amount is plus or minus 15%, then you can submit a claim. If it's more than 15% change, and your costs have increased, whereas the government can also come back and request that price be reduced if it's changed by 15% as well. So one of the most common types of claims that we tend to see are delay claims, where the government does something during performance of the contract and the entire contract is delayed. Normally, that's not necessarily a stop work order. That would be sort of the cleanest approach, and that has its own rules to it. This tends to be where the government or the contract specifically said that, let's say, you can work 24 hours a day on a project, if it's some, say, construction project. You can work 24 hours a day and you can excavate around the clock and do whatever you need to do to get things done. Then it turns out the government comes in and says, no, we're not going to let you do that. You can only work after 7 a.m. and you have to wrap up before 6 p.m. because the work you're doing is disrupting the sleep patterns or something of the government personnel. Well, then that's something that's going to delay the work that you're doing on that project and cause things to take more time. So when something like that occurs, if it's occurred, any of the costs that you're incurring during the extended period of performance due to that sort of delay is something that you can request payment for and profit on. If you have unabsorbed home office overhead, which is essentially where you have to have sort of management personnel or other resources attributed to at the home office, attributable to work that you're doing on site. The on-site additional overhead costs are things like general conditions, where let's say it's a construction project and you have a backhoe that you have to keep on site, porta potties, things like that you're constantly paying for, and you only expected to have 100 days of those things. Now you have 150 days of those things. Well, the additional 50 days of those costs, both at the home office and your site conditions, you can include those in your claim, including profit. Material cost increases. If sometimes I've seen it where you have to tarp a certain facility. The tarps are only good for a 30-day period before the materials break down or there's risk of breakdown, so you have to replace them. Those sorts of material cost increases, or lost productivity, which can often occur where you have some delay caused by, say, differing site conditions, where the soil you're digging through, instead of being normal topsoil or some sort of clay, tends to be some, say, compacted road base, which is like a bunch of hard materials, recycled concrete, things like that. You can't excavate that material normally. It takes a lot more effort, and that it takes a lot longer to do that. So now your productivity has been impacted severely, and you might not be able to move your heavy equipment from one part of the project to another as quickly as you thought. That lost productivity is something you can also assert a claim for, and any other damages that you can come up with. With regard to specifically on unabsorbed overhead, this is something that normally only applies to construction contracts, but it's been expanded recently, or people have tried to expand it, including myself, into other areas, including service contracts, where there has been a delay to the contract as a whole, and you can't specifically cite what your unabsorbed overhead was. Let's say you have one home office and it's used for everything. So it's not like you kept a separate office up and running and you have electric bills and water bills and things like that directly attributable to one contract. If it's unclear what your additional costs were, but it's clear there were costs, that's whenever this formula called the Eichle formula, which comes from this Eichle case, comes into play. So in order to actually claim this and get unabsorbed home office overhead or unabsorbed overhead, what you need to show is that the government caused the delay, only the government. If there is a delay that's concurrent delays from you and the government, or the contractor and the government, then you can no longer get unabsorbed home office overhead. The contract has to actually be extended, or you can prove with documents contemporaneous to when you bid the project that you plan to finish early and were unable to finish early. And that you were on standby in addition to that, which means essentially the government personnel told you as soon as this delay is over, you need to get right back on the project immediately without any downtime or any ramping up. To the extent the government does not tell you that you're on standby, or you don't seek some sort of statement from the government telling you that you're on standby and you have to immediately return to work, the courts, or the way the law comes out, is you're expected to remove all your equipment and mitigate costs as much as possible, and you can no longer get unabsorbed overhead. And in addition to that, not only do the first three things have to apply, but it also has to be impractical or commercially unreasonable for the contractor to mitigate the costs you've incurred through other work. So removing your backhoe from this job and putting it on another job. Just because circumstances might make it not feasible, or in your opinion not something that's reasonable, that's not enough. So if I had one case where it was construction in Alaska and there was a delay that pushed everything into the winter months where there could be no work could be performed because it's just too cold, the earth is frozen, you can't dig into it. The government basically said, in denying the claim, that you should have fired everybody and sold all your equipment because we weren't sure when you were going to come back to work, but you knew it couldn't have been before March. So the fact that you had stuff sitting there from November to March was unreasonable. And that's just a good example of where the contractor, and it makes perfect sense that there was nowhere else to take that equipment, but the fact that they'd let it sit on site instead of trying to lease it or sell it even, caused the claim to be denied. And then what the actual Eichle formula is that you take your overhead allocated to the entire project. So you have all of your overhead. Let's say you have 100% of your costs right, that your whole company has incurred during a given year, and you look at how much of your total revenues came from the job that was delayed. So then you know what percentage of your revenues are attributable to that one project. That will allow you to take whatever your overhead cost is, divide it by that amount to get your overhead cost for that project. Then you can divide it by a number of days, which then allows you to take to have a daily overhead rate, which you then multiply by the total number of days of delay. Now that sounds very confusing. It's not really as confusing as it seems, but that's why the Eichle formula is generally difficult to prove, and it's also disfavored to the extent you can show actual costs. So just something to keep aware of, that this is a key formula that is used quite often, but you can only use it if you can't otherwise prove your costs, and direct costs never fall into this. This is only for calculating home office overhead that has not been absorbed due to some sort of delay. Another very common item that comes up when you're talking about claims are differing site conditions. There are two types of differing site conditions. One is where you have a condition on site that is materially different and causes materially increased costs that was different from what you were given when you bid the project. So you put together a bid assuming that you have to excavate a certain project and that it's supposed to be some sort of clay material. When you get there, it's solid rock, right? That's something where you couldn't necessarily tell, and it was unusual, and it's different from the information that they gave you, and the government knew about it. So a lot of times this comes up where the government has as-built that they don't give you. So they know what the actual project was, but for whatever reason, they don't give it to you, and they represent that it's something else, or that it's normal conditions similar to the way it is in the area. Or you get blueprints that are different from the as-built, and the blueprints show that the foundation only went out 5 feet from the building. You get there, it goes out 15 feet, and that's exactly where you're supposed to be excavating. That's the kind of thing that's sort of a type 1 differing site condition. Whereas a type 2 differing site condition is where, to go back to the excavation example, you're supposed to be excavating. The government should know what's there, or there's no way that you would know what's there, and you're relying upon just what's normal for that physical location. So, for instance, if you're in Texas, there's a lot of brown, what they call clay brown fat, which is this like thick clay material that's highly expansive. Well, if you're starting to dig through that material and it turns out that it's not that, the whole site is on some sort of landfill from other construction, and there's a bunch of rebar and other material that you have to dig through, that's something that's an unknown and unusual condition that differs material from what's normally there. So the government didn't tell you anything, but at the same time there was no way for you to know it. Then you can also recover under differing site conditions claims.
All right, thanks. I'm going to pick up here and talk about claims related to wage adjustments. This is a common occurrence for a lot of our clients when there's a new collective bargaining agreement negotiated after the start of contract performance, or the Department of Labor updates a wage determination applicable to the contract. And so then the question becomes, well, how can we the contractor, get the contract adjusted to cover the additional expenses we're now going to incur based on the higher wages in the new CBA or the new wage determination. So there's a contractual REA claim process for doing that. There's typically going to be an economic price adjustment clause in the contract. It's probably your trigger point for starting that process with the government. Importantly, the new CBA or wage determination has to be incorporated into your contract in order for you to be required to pay on it in the case of a wage determination, and for you to get reimbursed for it in the case of either CBA or a wage determination. So it's important to make sure it's in your contract, or to follow the steps to get it into your contract. With respect to a CBA, the typical timeline is going to be that you need to get a copy of the CBA to the contracting officer at least 30 days before the start of performance for the new contract period that's going to be covered by the CBA. So as an example, if we had a CBA getting ready to start for the next contract year as of October 1st, then we're getting pretty close to the time now in almost August where we would need to be getting the new CBA to the contracting officer so we could get the wheels turning on an adjustment to get that new CBA into the contract and the rates adjusted. The wage determination, you're not required to pay on it until it gets into your contract, and the government isn't required to reimburse you until it's in the contract. So, there's, I think, one perspective that, well, look, it's not really up to me, the contractor, to get this into my contract, and that is correct. The caveat for that is that the DOL could, if they come in after the fact and say, you really should have been paying under this this new wage determination for the last couple of years, and they make the agency incorporate it and they make you go back and pay back wages, that could be a black mark on your record that, really arguably through no fault of your own, because you were just complying with what was in your contract. So it does, now that the DOL is getting more aggressive and we have more requirements or avenues to make these black marks on contractors' records, it's raising a question about whether you should be more proactive when you, as a contractor, when you learn of a new wage determination. When you go for an adjustment related to a change in wages, it's also important to know that the clause, the economic price adjustment clause, allows you to recover the delta between what your employees were making and what you now have to pay them under the new wage determination or the CBA, but not additional profit and G&A and overhead on those wages. So, one of the pieces of guidance that I know our labor and employment attorneys always say is that you should escalate your profit throughout the out years of the contract, but don't escalate the wages themselves, and that way your profit won't be watered down, and that goes to one of the questions that I see has popped up. But if you don't want to escalate the wage rates, because you want the wage rates to be escalated based on the wage determination or the CBA that is in effect. You don't want to do it yourself, and that preemptively, because that goes to the last point here, and I've seen this happen to several clients where they're aware of a wage determination that is going to come into effect, or they think is coming down the road, or maybe it's just that these are particularly good employees and they want to pay them a little bit more. You undercut your ability to get the full amount in a claim if you are already paying above the current wage determination, because you only get the delta in your claim between what you've been paying the employee and what you're now required to pay them. So I had a case where what they were already paying the employee, they just voluntarily increased the wages, and it really effectively neutralized our ability to go in and ask for a claim to retroactively increase the payments, because there was basically nothing to claim for. So that's an important thing to keep in mind.
Yeah, and one other thing, just really quickly, is there's a new proposed rule I'm sure we've all heard about where they've redefined non-exempt employees. It used to be about $23,000 a year, and now it's going up to what they think is going to be about $47,000 a year or thereabouts. And that's important to note because a lot of, or it's possible that a lot of employees on certain contracts were considered exempt, and so you didn't have to worry about overtime. You didn't bill overtime. The government wasn't allowing overtime, and it wasn't a problem because they were salaried employees making, you know, close to $50,000 a year. Well, now that they're raising that minimum threshold from 23 to 47, you could have employees that are caught in a situation where once the law changes, you have to pay them overtime. The government's not allowing overtime, and that's going to cause potential claim or REA issues to arise. In addition to that, if your employees were making less than or more than 23, they were exempt, and therefore maybe you would have had a Service Contract Act issue, but because they were exempt employees, you didn't have to worry about it. Well, once this final rule comes into effect, you might now have a Service Contract Act contract where it did not exist prior to this going into effect. And that means you might have to worry about not only increased wages, but also fringe benefits and how you're calculating that. If you're salaried, you might not be allocating fringe versus wages, and that could potentially get you into some DOL issues. We might have our own webinar on that whole issue by itself, but it's just something to take note of. So pay attention with these sorts of wage determinations issues. Pay attention to that new rule that's coming into effect because it could impact things and cause a lot of claims.
Yeah, like I said, I'm sure we'll continue to have more information coming out on that to help you stay on top of it and pay attention to it. So next slide is know the limits of the government's authority. This may seem like a common sense point, but we see this come up a lot that you took the direction of a government official in doing something on a contract, maybe a change or some additional work, and you later submit your claim to get paid for or get the ramifications of that change, and the government refuses, and their defense is you weren't authorized to do whatever it was that you did because the person that told you to do it didn't have authority to tell you to do it. And so it is a very important point. Who has authority to bind the government? Just a list of the typical people here. Appointing of authority should be in the contract. And if you don't see it in your contract, who's authorized to tell you to do work or to make changes or to sign? If it's not in your contract, then ask, because there should be something in writing that's specifying that authority. So it's really clear. If you're not sure, if it's somebody that's not the CO who you're dealing with most often, and you're not clear what their authority is, and the contract doesn't tell, find out. And so the next slide kind of dovetails on this. When is the government bound? They're bound when the official acts within the scope of their actual authority. So we can't argue that person who told you to go build that extra wing on the building had authority to tell you to do it just because we thought they had the authority, that they had apparent authority. Apparent authority doesn't get you. There's got to be actual authority. Now, there is a theory on implied actual authority, that the government may be bound if an official, if the government intended to grant authority to a particular official but failed to do so, and that authority is considered to be an integral part of that particular official's responsibilities. But that's not an easy case to make. I don't think that's a very common occurrence that you can bind the government through implied actual authority. So we're not being flip when we say don't bet the farm on doing something based on a theory of implied actual authority. Much better off to make clear that the person you're dealing with actually has authority. And the final point is, and this does happen sometimes, that an action may be unauthorized when it was initially taken, like it was authorized by someone who really didn't have authority to authorize it, which means at the time then it really was an unauthorized action, but it could become authorized later if it's ratified by somebody who was an authorized representative. And the one way I see this come up a lot is when somebody other than the contracting officer is doing all of the communications, but the contracting officer is copied on the emails. And questions come up about, well, does that make clear then that the contracting officer was in the loop and had authorized what was happening? I think you have a good argument if the CO was in the loop, and in particular the CO may have delegated authority to whoever that person was that was actually sending the emails, but it becomes a little bit dicier if the CO's not even in the loop, they're not a CC on the emails. Duty to cooperate. This is just something we want everybody to be aware of, that the government has a duty to cooperate. So keep this in mind when you're negotiating with the government and when you're potentially putting together claims. There's an implied obligation that they have to carry out their duties under the contract in good faith. They can't hinder you. And one example of that would be, if you're supposed to build something for the government and they're refusing to open the gates so you can't get in to do your work, they may be hindering your performance, and there could be a claim then based on the cost that you are incurring as a result of their failure to cooperate with you. And what we mean by this third bullet, that the duty of good faith is limited by the original contract, the parties have to act consistent with the contract. So it would not be consistent with the government's duty of good faith if they ask you to do something that's completely inconsistent with the contract, or it's going to deprive you of the contemplated value of the contract. So this is another way that you can bring in a potential claim, another angle to pursue. And the last point here I think is an important one, that bad faith is not an essential element of a breach of the implied duty of good faith. Bad faith is really hard to prove against the government. The standard is extremely high. So what I've been hearing, in fact, Cy was telling me shortly before we got on here, that the DOJ, when they handle claims, when they get before the Court of Federal Claims, they're pushing to try to require bad faith to be an element of a breach of implied duty of good faith. But to this point, it's not. So that means it's a lower standard of proof then for contractors to include this type of element in a claim. Another practical tip here popping up on your screen, born from a lot of experience and tough answers and disappointed clients, is to watch out for waiver language in modifications and other documents from the government before you sign. Because when you come to Cy or me to say, hey, I want to submit a claim based on these invoices that the government never paid, and we say, well, show us the modifications related to that work that you did, and the modification has really strong language that says you're waiving all rights to any additional monies or claims associated with the work covered by this mod, we may tell you, thanks, we'd love to do the claim, but you don't really have a good case. It's not worth it because you basically signed away your rights. So, and if it's an unambiguous, we may have arguments we can make about the extent of the waiver, was it ambiguous or unambiguous language, but if there is waiver language in a mod, be careful before you sign it. Or if you think there's a possibility of a claim, put something in that modification to say, look, we're by signing this, we're not waiving our rights to, we're reserving our right to submit a claim later on a particular issue we still need to look at. You're not required to have it all figured out at that moment, but you at least want to make sure that your reservation of rights is clear before you sign. Use of experts and consultants is another tip that is helpful for many claims. I mean, I think you have to make a judgment call, and that's something that Cy and I get involved with clients. You know, what claim, what type of claim is appropriate to bring in an outside expert. It's not going to necessarily be all claims. And there'll be a variety of factors that will help make that determination. But complexity of cost issues, you know, Cy talked about the delay type claims and Eichle formula. I mean, there are certain things that you probably don't want to calculate or get involved with yourself, particularly when you have to certify the claim. So you're signing your blood oath that everything in that claim is accurate, and you know, do you feel comfortable that you can really sign that blood oath if you've done it all yourself? And I know Cy had an experience, and you may want to share that, you know, the lawyers don't really want to end up doing the calculations either, because you don't want to end up being a witness in your own claim if you know, you're carrying the claim forward on behalf of the client. So you know, thinking through and when is it a good idea to bring in experts and consultants, and it is oftentimes, particularly for the more complicated and the larger claims, to do that. Investigate local rules. You know, many of you may do projects not just with the federal government, and it's often the case that state or local projects will be subject to their own claims procedures. Some may follow or look very similar to the federal guidelines, and that's what we've really been talking about today, our federal guidelines. But there are lots of state and local agencies that have their own procedures, and they may very well be different from what you're used to in the federal government. So I take the DC government, for example. We've got some work there recently that, you know, really shows you the importance of understanding where you're at. You know, what's your forum and what are the unique requirements? Because the DC code has requirements that in some respects are very different from what you find in a standard procurement contract with the district. So, you know, you're used to, I think, well, my contract controls. What it says in my contract is what I have to live and die by. But in DC, there are some DC code provisions which, you know, you're probably not walking around having, you know, perfect understanding or awareness of, that differ from your contract. And the DC Board of Contracts Appeals may say that the contractor has constructive notice of those DC code provisions, meaning because it's the law, you're supposed to know it. And so even if your contract says something different, that may not prevent you from having to follow these different provisions that aren't even in your contract that you may not have known about. So, you know, really understanding the forum and the local rules is critical. So now I'm going to talk about subcontractor claims briefly, we'll leave a little bit of time for the appeals process at the end. We're coming up on 3, and like I said, we're going to run over a little bit since we started late, so we hope everybody can hang in there with us. Subcontractor claims are different than prime contractor claims because the subcontractor doesn't have the right to submit its own claim to the government. The reason the prime contractor can submit the claim is because the prime contractor has what's called privity with the government. They have a direct contractual relationship with the government, but a subcontractor does not. The subcontractor has privity with the prime contractor. So the way that you can get around that as a subcontractor and submit a claim to the government is by doing it through the prime contractor. So this is called sponsorship, claim sponsorship. So the prime contractor says, I'll agree to sponsor this claim from my sub, and it gets submitted in the name of the prime contractor. And so issues arise, and we noted this Binghamton case last year because it's a good example of these issues, between the prime and the sub as to whether the prime is agreeing to sponsor the claim. And in this Binghamton case, there was a subcontract agreement, and the subcontract agreement had what I would consider to be standard language about claim sponsorship that said something to the effect of, look, if the prime contractor decides not to carry forward the claim, the sub has the right to do it, and went on from there to describe what the subcontractor, what its right was to carry it forward. But that did not specifically address the prime contractor's agreement, sponsorship of a particular claim. And so what ended up happening in this case is that the subcontractor got into the appeal, and then the Armed Services Board of Contract Appeals said, well, we want to see the evidence that the prime contractor sponsored this appeal. And the subcontractor pointed to the subcontract and said, well, here's where the prime said we're allowed to do this. And the prime contractor said, nope, we're not sponsoring it. We didn't sponsor this. And so the ASBCA kicked the appeal. And I don't know the history of their inner workings, why the prime decided at that point that it wasn't going to stand behind the subcontractor's appeal, but that was fatal to the subcontractor's appeal. So this is an important issue to try to address as best you can in the subcontract. And obviously, depending on what side of the fence you're sitting, you maybe care more or less about the details here. If you're the prime contractor, maybe you're not necessarily looking to make it easier for the subcontractor to submit the claim or to put more responsibilities on yourself. But if you're the subcontractor, you really do want to try to build as much specificity as you can into the subcontract agreement to make clear that the prime will sponsor your claims and give you something in writing to memorialize their sponsorship at the time that you're getting ready to put forward the claim. You want to write it so that it's almost automatic that the prime has to do that as best you can to take out the potential that maybe they would play games with it when it comes time to submit the claim. Sai, did you want to touch on the Severn doctrine quickly?
Yeah. So just to go quickly, because I know we're running out of time, but the Severn doctrine is something from the case, from a Severn case, the name of the case, where it used to be that if the subcontract had language in it stating that prime contractor will pay subcontractor to the extent that prime contractor is paid by the government. And back whenever Severn was decided, it was found that any clause like that which limited the prime's liability to that which the government actually paid actually barred any contractor claims, because as that case stated, if the prime is only bound to the extent the government pays, then the prime isn't really bound at all. And so because the prime isn't incurring any costs, there is no subcontractor claim in reality. Now, that's been walked back a little bit, so by case law where they found it was too harsh. But if you're a subcontractor, you want to make sure that whatever clauses are in the subcontract don't cross that line under Severn and its progeny, so that you're not accidentally walking into a situation where all of your costs are essentially barred from being recovered. And because this is a matter of case law, it's not a creature of statute. You know, the winds could go back the other direction at some point if the Federal Circuit decides to go down a harsher path, which the Federal Circuit has been known to do. So just be careful with those sorts of issues. And then we'll quickly go through some of the appeals process, just because I know we're running out of time. So appeal, once you file a claim and the claim is either denied within the 60-day period, or the contracting officer is silent and it just sits for 61 days, you can deem it a denial, and you could take that appeal up to the Board of Contract Appeals that's relevant for your agency. So the ASBCA is for DOD, the Corps of Engineers, any of those military bodies. And the CBCA, the Civilian Board, is for all the civilian executive agencies. There are other boards of contract appeals. There used to be a lot more, but now the only other boards are for, say, the Postal Service, FAA are examples, or GSA, because that's not an executive agency. Your other option, aside from any of the boards, is the Court of Federal Claims. One thing to think about when you're choosing the boards of contract appeals, or the court, is that when you go to court, the agency is no longer involved, and the Department of Justice takes over because it's an actual lawsuit. And that can benefit you or it can hurt you. If your strategy is to get DOJ involved to put extra pressure or get a new pair of eyes on things, that might work, but you should be aware that it's DOJ's policy to not negotiate until after discovery has completed. So that's a lot of time and a lot of cost. Whereas at the BCA, you might be able to get the agency to continue negotiations after you've filed. When you're talking about the boards of contract appeals, you have to appeal within 90 days of the CO's final determination. So when the contracting officer issues an actual final decision on a claim, that starts your clock. If they've just been sitting on it, you could, in theory, wait longer and longer periods of time before you file something. And in fact, I have one case where it's been years. But you might not want to actually wait that long.
You can also, Shai, correct me if I'm wrong, you can ask the board to direct the contracting officer to issue a decision. So as opposed to saying I'm appealing from this deemed denial because they have never made a decision, you can say, and I think it's maybe a little softer approach, they kick this back to them and direct them to make a decision. And we were able to settle a case once just by doing that, where the CO hadn't been issuing a decision, and we finally filed just asking the board to direct the CO to make a decision, and then we were able to settle at that point.
And also there are some other procedures you might want to take advantage of. If it's a small claim, if it's under $50,000, or if for small businesses, if it's under $150,000, you can use the board's expedited procedures. And also for claims that are $100,000 or less, there's some accelerated procedures. So the small claim procedures are really fast and have a much lower discovery bar and less time in discovery, less costly. The accelerated procedures are a little bit more expensive. You get a little more discovery, but it's still less than a major claim, which has full discovery, witnesses, depositions, you name it, everything, and a lot of extra costs. So just something to keep in mind. The Court of Federal Claims, the rules are a little bit different, as you can see on the slide. It takes a little longer, but they also have expedited trial procedures where you have a shortened discovery period and a shorter trial. So in the general procedures, discovery can last months and months and months and months, and trials can go as long as they need to. So with these expedited procedures at the court, you also get a little bit of a break and things are sped up. In addition to those expedited procedures, both at the board and the court, there are ADR procedures at both of them, so you don't have to go through a full trial. You can request mediation, some sort of evaluation, or you can actually go and request actual arbitration, which can be binding. So that can also be helpful if you think there's a chance that negotiations could work, but the parties are at each other's throats, or you want someone who's going to come in and be the referee. Filing an appeal with the board or the court can grant you that. I'll also note, though, that at the board, there is also a procedure for ADR without filing. And I have a case where we went to the Court of Federal Claims, but then decided to dismiss our case because the agency really wanted a chance to negotiate after they saw our evidence and DOJ kind of got involved and told them they should negotiate. So we dismissed our case to get the agency back involved, and we're at the board going through their ADR procedures without actually filing the appeal. So that can also be an option. So I think we're a little bit over, but we caught up some time and might try to go through some questions.
Yeah, let's see if we can answer a couple before we need to run. So the question here on what's the citation for the Severn case, I don't think we have it with us here, but to the questioner, we will send the citation to you after the presentation. Somebody asked, can you address how to file a claim for a CPARS evaluation that we believe is incorrect? That's a good question. I mean, you want to start with getting your objection registered timely. Is it 30 or 60 days, Si, from when you first learn of I actually have one of these that's just starting. I just got notice of this yesterday, so I need to refresh on the timeline there. But then ultimately, yeah, I think it's 62. Ultimately, your disagreement with the rating, if you post your opposite conclusion, you submit it, you can submit that in the form of a claim letter to the contracting officer and carry it forward like a Contract Disputes Act claim, just like any other claim we've talked about today, with the rights to then appeal it afterwards if they don't agree.
Also, check the agency's procedures if they're published online or you otherwise have access to the agency-specific procedures for the CPARs, because if they did something procedurally wrong, that can also be a little bit stronger than an argument about facts. Now, that's not to say you can't argue facts with a board claim or the Court of Federal Claims. If it gets that far, you can certainly argue that they're factually inaccurate. In fact, the standard is inaccurate and unfair. So you have to allege that the CPAR is inaccurate and unfair, otherwise had some sort of procedural flaw. And it's a claim like any other. You just file it with the contracting officer and take it from there if it's denied or if it takes too long.
Yeah, and to the questioner, we'll follow up with you afterwards to get you a confirmation on the timeline that we're a little bit unsure of, but both on the same page here that it gets submitted like any other claim. It gets processed from that point forward. So your deadline to ultimately submit the claim, et cetera. Somebody asked about the date when the final rule that Si talked about with the raising of the non-exempt salary will go into effect. I don't think we have a target date for that. I mean, is the public comment period closed at this point? Do you know, Si? Yeah, we'd have to check on that, but it's always difficult to predict when final rules are going to come out. After a public comment period closes, it can be anywhere from 3 months, 6 months to more than a year, depending on how quickly the agency can move to work through the public comment. So, I'll ask around here to the questioner, and if we find out any more information we can pass on, we will. I think we're going to wrap up there. There were a few questions left. We will email each of you separately